we do have an interest in everything that occurs on the reservation, whether it's by non-tribal members or tribal members or a mix of the two. We have a very, as much interest as any other government does.
If you come onto a reservation, I think you should be subject to the laws of that tribe like any other nation.
Do you and each of you solemnly swear to well and truly try this matter and issue between the Confederated Tribes and render a true verdict according to the law, so help you God?
After they ran away, what happened? Keith took off running through the field.
You have a right to review all evidence that may be used against you prior to a trial. You understand that?
Yes.
Although I have no Indian reservations in my home state of Hawaii, I've served on the Senate Committee on Indian Affairs for the past 20 years. During my 8-year tenure as chairman of the committee and my 4 years as vice chairman, I've witnessed significant developments in the operations of tribal governments. I believe that it is clear that to exercise their powers of self-government effectively, Indian governments must have strong, credible tribal judicial systems.
All rise.
You can be seated. Court's in session.
Tribal courts play a crucial role in the administration of justice in Indian country. The challenges they face include complex jurisdictional issues and highly mobile population of Indians and non-Indians, both on and off reservation lands. In order to provide for the safety and security of tribal communities, it is imperative that tribal courts receive the cooperation and support of the state and federal courts and the systems which support those courts.
So I think we share.
There are good working relationships being built between tribal and state court judges.
Working out.
Please join me as we meet some of those judges and take a brief look at tribal courts.
Mr. Strong, are you represented by counsel, legal counsel? And you have a couple matters here, one alleged driving under the influence of intoxicants and one no Oregon driver's license. And it looks like you, have you made a plea to this yet? Doesn't look like you did. You want to make a plea to this? I want to say that the driving under the influence of intoxicants, you may have a right to a diversion program. Did I advise you of that before?
No.
Okay.
I'm eligible.
You're not eligible?
Yeah.
Okay, you can have a seat, Mr. Strong. Did you understand the sentencing authority of the court is $5,000 or 1 year in jail?
Yes.
Okay. I am a homegrown tribal enrolled member of the Umatilla tribe. My mom's an enrolled member here, and my dad was an enrolled Miss Purse, and graduated from Oregon State University, and then University of Oregon Law School. I've been around since it started, and I can remember at a time when we didn't have a court and we wanted to have better safety calls to our tribal community, better response time.
Morning, Judge. How you doing? Yeah, it was. I just came by to check in, see what's going on.
You got my 5 o'clock call this morning, huh? We didn't have a police or a court system, and we wanted enforcement of laws on the reservation and to do it ourselves.
For a period of 25 years, the state jurisdiction made it worse because there's unfairness to all of our people, especially the parents, adoption of children out of state, arresting people on our reservation, murders that never was taken care of, theft, and lots of rape never was done. It was unfair. They never looked into it.
The Umatilla Tribal Court was established in 1975 and exercised jurisdiction basically over hunting and fishing cases, as well as juvenile matters, as well as some housing matters. Since that time, in about 1979, we retroceded exclusive criminal jurisdiction from the state and exercised that up to the present, as well as expanded jurisdiction in civil cases, in employment matters, in contract matters, in water law cases, zoning, that traffic, those types of matters, and major criminal offenses. And I've been exercising that jurisdiction up to the present. And our caseload it's expanded drastically in the recent history because of expanded police activity as well as expanded activity on the reservation.
We patrol approximately 240,000 acres, including the seeded areas that we patrol in fish and game. I would estimate several hundred miles of roadway, back roads, paved highways, and even an interstate through the reservation.
Our tribal police are cross-deputized with the Umatilla County Sheriff's Department because we're largely a rural area encompassing the reservation and the adjacent area. And they are cross-deputized here to a limited extent to come on the reservation and make arrests. We also have a formal agreement with the state of Oregon about fresh pursuit and extradition and making arrests on each other's warrants, which has been very helpful to getting that cross-border smooth enforcement that you want to have in this kind of situation.
Are you prepared to make a plea at this time?
Yes.
Okay. And the citation reads that on or about September 3rd, 1997, within the reservation, that you were allegedly driving under the influence of intoxicants. And how do you wish to plead to that, Mr. Strong?
Guilty.
Guilty? Do you have any statement or comment?
No.
Okay.
He admitted that he didn't have a license. He appears to be an enrolled Yakima Indian. They transported him here to the tribal police department next door and administered the intoxilizer test, and he consented to it, took it, and read a .29 blood alcohol.
I'm sorry to interrupt.
Hold on for a minute.
If I may, we've been chatting a little
Okay.
bit while Ms. Hampton was reading, and if he could, he needs, I think, really to come in and just chat with me just a little bit to understand what's going on as far as his rights that he's giving up. I know it's a little late to do that, but if he could withdraw his guilty plea and enter a not guilty plea, he needs someone to sit down and go through that plea petition with him. You're confused?
At that point, he had technically entered the guilty plea. Had I been in my state court prosecutor mode, I would have said, sorry, Your Honor, you know, the bell, you can't unring the bell. But that wasn't appropriate in tribal court, because in tribal court, we seek to ensure that the defendant understands exactly what he's doing and that his fairness has been extended to him.
You stay in contact with Ms. Cobbizons and be sure and do that. If on 7/13/98, if we give you the notice today, if you don't appear, we'll issue a warrant for you. You understand that?
Yes.
To the degree that tribal court is more casual or has a less leaden weight of procedure, it's reflected in proceedings like that.
The white man court did ask him, "You think you're guilty?" And the man would always ask, "I guess I am," and give him 30 days for saying that. There was no fairness to the Indians in the state courts. Never read them their rights till just lately.
What do you think traditional law in our community is? I mean, could you explain it?
Well, I think the Anglo people call our traditional laws, common laws. The Indians had it here for a long time. People like chiefs or second chief, war chiefs, or somebody that's well-to-do people took care of their times when they disciplined them or give them punishment. They were respected too.
Initially, the United States government had little interest in crimes committed by one Indian against another, or in disputes between Indians. Such matters were customarily handled by tribal common law and custom and thought to be within the exclusive jurisdiction of the tribe. However, in 1883, the federal government introduced the adversarial trial process in Indian country by establishing courts of Indian offenses, which were controlled by Indian agents. While the federal policy at that time was one of assimilation, other federal laws and policies also encouraged the breakdown of traditional tribal practices, including the General Allotment Acts, which resulted in the loss of millions of acres of Indian lands to non-Indians.
It is what we call a checkerboard reservation. which means that there are white people and there are Indian people. And that was basically through the Allotment Act when that happened, and which really allowed the white people to buy Indian land. That was one of the stipulations of the act, that the land, the Indian land, could be sold or it could be leased, and a lot of it was sold. That explains the presence of the non-Indians or the white people on the reservation. To this day, they own approximately 50% of what we call a diminished reservation.
These devastating results of the allotment period led to the 1934 reform of federal Indian policy with the enactment of the Indian Reorganization Act. Many tribes organized under the act, adopting written constitutions which authorized the establishment of tribal courts. These new tribal courts derived their authority and power from the inherent sovereignty of the tribes, rather than as a function of federal law. The Supreme Court reaffirmed the scope of tribal judicial authority as arising out of each tribe's inherent sovereignty 40 years later in a case known as United States versus Wheeler.
All right? Courts in recess. I personally handled anywhere from 1,500 to 2,000 cases a year, primarily in criminal cases. Our chief judge handles primarily juvenile cases, although all of the judges handle a percentage of them. We also handle standard traffic court. We exert civil jurisdiction, two-party cases, as well as exerting civil jurisdiction over non-Indians that commit acts that would be a crime if committed by an Indian.
In 1978, in the case of Oliphant versus Squamish Indian Tribe, the United States Supreme Court declared that tribal courts did not retain the inherent authority to exercise criminal jurisdiction over non-Indians. This ruling dealt a severe blow to the comprehensive administration of justice on Indian lands and to the jurisdictional growth of tribal courts.
My position is that any government has a very strong interest in everything that happens within the boundaries of their territory. It doesn't matter whether it's something that's done by a citizen or not, if you're in the state, or whether it's a tribal member or an Indian or a non-Indian on the reservation. Just the fact that we're the government and responsible for peace and order and safety of people within our boundaries, I think that gives us the authority to take whatever actions are necessary within reason to make sure that everybody is safe.
We do exert civil jurisdiction over non-Indians. A non-Indian that commits an act that would be a crime if committed by an Indian, we exert civil jurisdiction. They do have a right to counsel. They have a right to a trial, a judge trial. We do have a legal aid services that will supply them representation at no cost to them. They are subject to non-criminal sanctions, fines, exclusion from the boundaries of the reservation. They could be required to pay restitution. They could forfeit property. If they violate a sentence, they can be held accountable, and that could involve incarceration on a civil contempt.
Our council doesn't require our judges to have a law degree. A lot of tribal courts are going to that now. And I guess for some people, that kind of raises the level or the quality of justice that they think they're going to get out of a court system. But in my experience, and I was a tribal court judge for 8 years full time, I couldn't see where, when it came down to fairness and justice being dispensed, that a law degree really made a judge any better. We have a chief judge now, Chief Judge Lola So Happy, who is really involved in family court and juvenile matters. That's her expertise. And she's recognized nationally by both tribal court judges and non-tribal court judges, federal court judges and state court judges, for her expertise in that area and for her ability to really find some solutions that work for families that are having trouble.
We also have our customs, our traditions, and our values that teach us throughout our lives that we are to deliver fair and just remedies for all situations, and that's what we attempt to do.
Not very many state court judges have worked in the tribal court system, so I mean it's basically just an educational process, and I don't think that burden should be exclusively on the tribal courts to explain to ours. We have an obligation to learn about their system. In our particular situation, I mean, they have a jail on the reservation for tribal members, and clearly there wouldn't be a jail out there unless through their court system they sentence people to serve in it. So they all certainly have consequences. The other thing is the tribal community is, you know, it's a much smaller area, and they're concerned with the same things we're concerned about, the livability of their community, etc. So I mean, if somebody's committing personal or property crimes on the reservation, those people want protected, and they look to their court system to offer that protection.
Being a small community, everyone knows what everyone's doing, and when they see justice being served, you know, they know the court is doing their job. This court does a great job of holding people accountable. We don't do a real good job of making them responsible. I think they have to do that. We have other programs that help with that, but we do a real good job of holding people accountable for their acts.
Restorative justice isn't a new concept in Warm Springs. In fact, I think traditionally, you know, that's how our people looked for resolution of conflicts between people. And it's been very easily incorporated into our Anglo court system as well as the family court system that we're developing.
We abide our tribal traditions and customs. If there's a question, as for instance, in probate or in juvenile law or in hunting and fishing, something that may be uniquely tribal, we understand that. We will honor that. We will respect it and give it, I guess, truth and credibility in our court system.
The tribal court is unique in many ways. Of course, the standard adversary system, we don't always go by that. We don't always utilize that way. We think by bringing parties together to resolve issues in more of a mediation type process works very well. Traditionally, families dealt with issues. There was no courts. There was elders and leaders that may have administered discipline, whip men, things like that. But commonly, it was the families that resolved those issues. And I think what makes our court unique is we compel those families to get in here, and here's the problem, what are you going to do about it? And 99% of the time it's resolved that way. And it has a very good success rate because they came up with it. It wasn't something that was ordered by me or any of the judges to compel them to do something. They had the answer, they did it, they policed themselves. And very rare does it have to come back to court.
Watching the tribal court operate is very much watching part of their culture operate as well. And that culture has a lot to teach us.
We recently had a case where it involved a juvenile being disciplined too harshly. And rather than bring it into the formal court setting, we opted to go, all of the family and the juvenile coordinator, all the parties involved, opted to go through a family court process, which they are still in the process of meeting. They have brought in, I believe, 2 of traditional people from the community that do the mediation, and that process is going well with several, I think, weekly meetings they're holding to talk about the situation that took place, and forgiveness being one of the main things that they have worked toward. And from talking to one of the family members that had been done, and they were truly working to a reunification of the whole family unit.
The Warm Springs Tribal Court is a combination of their cultural background and some of our structure with certain constitutional minimums that are in place. the freedom that they have to operate with their culture being incorporated into the court system oftentimes provides a much more holistic approach than the state court system does. In some respects, state court systems are moving that way by the adoption of mediation programs and community dispute resolution type work. And I really believe that the citizens that leave the cases that go to those community dispute resolution programs are oftentimes much more satisfied than they are when they reach court in our adversarial system.
Other teenagers in matters that I've went to school with and grew up around that are not tribal members, I believe they are a little bit prejudiced or not really prejudiced, but don't understand why we have to have separate things and separate needs.
It's amazing how naive the non-Indian population, you know, is towards the tribes. You know, they always talk about, oh yeah, we're involved. You know, in the local paper they put in you know, the powwow stuff and all this great stuff showing Indians in their regalia and all that, but they don't know squat about the tribe's government, the tribe's resources, the tribe's limitations.
Non-tribal members that get a speeding violation from a tribal police, they feel that maybe that they stand out a lot more because they're white or what else, whatever, just because they're down there in a place where they're not really familiar with, they don't know all the laws. Of course they're going to feel some kind of unfair treatment towards them. So
I think that there's a fear nationwide that Indian courts somehow railroad non-Indians, for instance. And we do deal with non-Indians in code enforcement. We don't have criminal jurisdiction over non-Indians, so we don't deal with them there. But they have all the same safeguards, they have all the same rights, the same notions of stare decisis, precedent, apply here as they do anywhere.
Every civil law that we exercise is also exercised over non-Indians, and it hasn't been a problem.
Tribal courts are important for people because they have their own settlements right here on the reservation. They have a lot of things coming since they have their casino and lots of housing. There's going to be a lot more motels, construction. They got to have some place where they can have settlements for Indian people.
Because of our gaming facilities and our economic development, we're having people come back on the reservation, non-Indian as well as Indian, and we're seeing that there's increased crime as well as violent crime.
The crimes on the reservation that seem to be on the rise are violent crimes, domestic violence, assaults, those kinds of crimes. Just recently, the Department of Justice did a study in Indian country and found that Indian country was rising in violent crime, almost in epidemic proportion.
What kind of weapon was that?
It's a 380.
380?
Yeah.
A pistol? Was it on your possession?
Yeah, it was underneath the seat.
Under your side of the seat?
Yeah.
Did you know it was there?
Afterwards, when I was getting out.
Is that we need resources for juveniles, we need resources for domestic violence, those types of things. Jurisdiction over non-Indians and expanded sentencing authority, more than $5,000 and more than 1 year in jail.
You are not admitting to the charges, but you are also not denying those charges. You are simply not contesting those charges. You give up your right or you waive your right to a trial. You understand that? You won't have a trial. You certainly have the opportunity to present any facts to the court that you feel is pertinent.
All courts must establish and maintain credibility in the communities for which they are charged to administer justice. Tribal court justice do engage in a range of outreach activities.
I think that Umatilla has been very successful in working with the community cooperatively, whether it's an Indian or non-Indian community. But that allows us to have a strong court system as well as a strong police system.
There's something called the Local Public Safety Coordinating Council. We call it LIPSIC. And it's a council involving all law enforcement officers, judges, defenders, law enforcement type personnel, and we meet periodically and discuss problems that may be happening off reservation as well as on, and how we can deal with those. So we think that that's important, as well as besides our jury pool being involving non-Indians, it explains some of the system to them. We also are involved in different training sessions. For instance, there was a municipal judges conference here, and we went and made presentation about tribal courts to that conference. I know most of the state court judges. I've known them before they were judges. One of the state court judges was actually our prosecutor for a while. And I've worked, of course, in the city court system and been pro tem judge for them. It's a real good working relationship, and we've had matters involving child welfare matters as well as custody matters involving Indian children that we may refer or at least confer about what's going to happen with them and what's the best for the case.
You were telling me about our next meeting, the juvenile law meeting for state court judges, in which you will be an instructor. That's a wonderful opportunity for all of us to learn more about rules affecting tribal members throughout the state. And those are often among the most confusing issues we face, and the most important issues of how to deal with all of our children, what's fair, what resources are available.
I won't speak for every tribe in Oregon, but I don't think they necessarily want to mix up anything that's even happening in state corporates. They want to be involved in the decision, and they may want to intervene and take the case back into the tribal court system and deal with it that way. That wouldn't mean that it's changed any circumstance of what the child's status is or where it's going to be, but the tribe wants to be involved in that decision. That's the way I believe that most tribes feel.
We're all trying to make this a government of laws, and where people are treated equally and fairly and justly, so that we get a just result.
What we're attempting to do in the 22nd Judicial District, and the tribal judges are committed to, it's sort of in the feeling out process. I mean, it's not that there's skepticism, but there's just a question as to how we can help each other. I think in the past, most of the contacts, a problem would arise, you'd talk to each other and you'd try to solve the problem. And we're trying to be a little bit more proactive now and just discuss areas that we may not have even thought about, and said, how could we work together? And I think that's the difference now. So I think there's a lot less anxiety when you're not talking about a problem and you're kind of in your separate turfs than when you're just saying, let's get together and talk. And then they say, well, what's the agenda? Well, we don't really have one. We just want to talk. We're judges. We work in the same county. Let's talk about what we can do together.
I don't think the problems here in Warm Springs are much different than the problems that are occurring in Jefferson County. Their population comes here, our population goes over there. It's all the same problem. We need to work together.
We are open to visitors. We have other tribes that visit us all the time. We have had visitations from New Zealand, tribal judges that have come through and visited our courts. So we're really open to anyone to come and visit and to learn about what we do, what we're able to do, what we can do, and what we have done.
All we ask is that you look at us as if we're doing the same type of job. We may be in a different nation, different sovereignty, but we still have the same tough job to do that all court judges have to do, no matter what you call them, what brand.
Under tribal law, any conviction, which you don't need to worry about when it comes to determining innocent or guilt, that's my job, or the judge's job who's presiding.
Tribal justice systems deserve the cooperation and support of state and federal court systems. Fair and equal justice for all people in Indian country is a goal that's being achieved through the dedication of the many fine individuals who work in tribal courts.
There was another judge there, or somebody said, we want you to see Judge Johnson, and I wanted to see you. Yeah.
As can be seen from this presentation, tribal courts must be protected and preserved not only because they are a fundamental and important component of tribal governments, but because they are perhaps the most critical and visible expression of Indian sovereignty.